I'm getting a probable cause, a copy of a probable cause affidavit that is prepared by an officer with the Beaumont Police Department. And this states that this event occurred on January 17th, 4 days ago. Well, you're on my bond in reference to to attempting to locate a stolen vehicle. I later located the above described vehicle at the Smart Shop on Avenue A, and a felony takedown was performed. Further investigation revealed that Reyes Castaneda, that's you, was located in the driver's seat of the stolen vehicle he was operating. Due to Reyes being located in the stolen vehicle and operating without effective consent of the owner, he was placed under arrest, secured in the rear of the patrol automobile, and he was booked in. And there's body camera footage on all of this. So this just happened 4 days ago. So a copy of this is going to be made and it'll be part of the record on this hearing. What's his bond?
One. He has 3 cases with us.
Mm-hmm.
Got it, 20,000, original, but there's a 1.35. Also 20,000. Standard. 2844. 15,000.
It's what?
15. 2020 and
55. All right. The state asking for.
Judge, due to the fact that he's been arrested on a new charge while on bond, we believe the bond to be insufficient. We'd ask his bonds at least be doubled.
Defense.
And Judge, as I'm sure you're well aware, bond is used to ensure that the defendant shows up for his court dates and that it's set sufficiently high enough to make sure that he does show up for those court dates. And even though we have this new issue that arose this past week, he got out yesterday on accusation, did not have to post another bond. However, he still showed up for his court date today. So my argument is that his bonds are sufficiently high enough as they sit currently because they ensured his presence at court today, a court date that he has had and that he knew about, and he was proactive enough to be present today. So I would ask that once the new indictment comes, there will be some kind of a new bond assessed for that, but I would ask that he be allowed to remain on his current bond and maybe increase the current bond conditions instead of revoking them.
I increase, don't commit another crime while you're on bond.
All right. The court is going to note that Article 17.15 of the Texas Code of Criminal Procedure sets forth rules for setting amounts of bond. The nature of the offense, circumstances under while the offense was committed are to be considered, including the future safety of a victim, law enforcement, and the safety of the community are also to be considered. And considerations of bond also include whether the defendant has complied with other bond conditions and the safety of the community and the circumstances of this crime, of the crimes that we're dealing with the defendant all show that he's free falling. And he is a danger to the safety of others. His bonds are revoked in each case, and they are doubled from 20,000, 20,000, and 15,000 in his three current offenses to 40, 40, and 30. So that's those are going to be the court ordered bond amounts. Plus, you must have a GPS device on you at all times. You must stay at home confinement. You can only leave home for purposes of emergency hospitalization or medical needs, to and from food sources in the most direct route possible, and to and from your attorney's office. Those are your exceptions to your confinement if you post this bond. What do you want to set next? An announcement here?
I'm not sure when the new offense is going to be indicted, but it makes the most sense to set it after that.
Let's look at a review in
maybe-
4 weeks.
Okay.
Okay. And Court's Exhibit 1 is a probable cause affidavit that is been prepared by law enforcement in this particular underlying case of the defendant being in possession of a stolen vehicle on January 17th of 2026. And it's prepared by the Beaumont Police Department, and it will be made a part of the record in each of these 3 cases. All right, anything else on this? Resolve. Xavier Curtis.
We just judge.
We already did him.
Yes.
Jose Castillo.
That's 3. We just did, so.
Jose Granados. And this is 25 CR 1179. What are we doing today?
Judge, I have spoken with Mr. Boyd. It's my understanding that this is going to be refiled as a misdemeanor. It would be handled as a misdemeanor, so it's
What? What offense?
resisting arrest.
Yeah. It's not a lesser included on this one. I don't think.
And Your Honor, in one of the reports, one of the elements is pretty much, I feel like it's negated in there. So we're dismissing this case, file the resisting, which there was clear resisting, but I believe that.
We just need maybe 2 weeks for me to get a new date of misdemeanor court so that it can be handled across the law.
I don't know what. Okay. I guess this court has jurisdiction for misdemeanor as well as felony cases,
Correct.
unlike the courtroom store. I don't believe the court has the same jurisdictional leverage as the court does. That's why I've never understood why we're having to go and refile information and then go through a whole process in another court, and then we're preparing 2 sets of paperwork, in each of the courts. I'm happy to do it here if we can figure a way to do it expediently, you know, that's what you care for and you just want it done, you know, so we can get it done.
The issue that we run into is there has to be a properly filed cause number of the new misdemeanor, and there has to be time to do that. But if you can do the misdemeanor, then
We have,
Yeah, and
we're,
normally we'll do
if
the,
we can figure it out, we'll figure it out. But right now, until we do, we'll just do what we'll move forward in that way we've been doing it, but I propose a better way.
okay.
It's just.
Well, look, yeah.
Since.
If we
Then
can
got
accomplish it that
court
way.
working on the same defendant, which is kind of convoluted, but it has historically been the only way.
and normally we would do the lesser judge, but
Yeah,
the element.
but that's not a lesser.
Right, the lesser that we would have done at the element is the second
assault.
we would need, yep. So
It would be
it's
just a simple
yeah, so
assault.
it's,
That's what, not y'all are asking for. Okay. All right, get a resetting to review it in 4 weeks. Okay.
Thank you.
And Manuel Hernandez,
He's a plea judge.
Mr. Arnold. 25 CR 1234 is called. What are the odds of that? You're Manuel Hernandez?
Yes, sir.
Present with your attorney, Ms. Manalvi, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about August 1st, 2025 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you were charged with?
Yes, sir.
Speak out.
Yes, sir.
This is a state jail felony. It means that if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine up to $10,000 can be assessed. You understand the punishment range applicable in this case.
Yes, sir.
An agreement has been reached where you would be placed on deferred, pleading guilty, placed on deferred or unadjudicated probation. It's up to the court's decision how much length, and it can be up to 5 years in on probation. But I always tell people that we don't need people on probation any longer than necessary. And I almost every day dismiss cases early for
Yes, sir.
good behavior. I can do it in a third of the time. So if you get 5 years, you could be on probation less than 2 years,
Yes, sir.
actually. 1 2/3. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
So that's good to know. Yes, sir.
You and your lawyer are both pleading guilty? Is that?
Yes, sir.
Oh. Are you pleading guilty
Yes,
in
sir.
this case voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it?
Yes.
Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence and without objection, it's admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged in any lesser included offenses, and you giving up your rights to a jury trial and the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
Anything else to add? I will follow this agreement.
Judge, I would like to state that I was not agreeing to the 2. I am actually recommending the full 5 years of the probation.
And Ms. Moore did make me aware of that. I just am offering the suggestion to the court because, as you said yourself, we don't want people on probation longer than
I don't.
necessary. In my opinion, if they're successful, then they're going to show that they're successful within the first 2 years of probation regardless. And I do think that this client will be successful, so we're asking for the 2 years of deferred.
Okay. Anything else? If not, I'm going to find you are pleading guilty, sir, voluntarily. Are you mentally competent so you understand and appreciate the consequences of pleading guilty? There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, but I'm not going to find you guilty. I'm going to place you on deferred or unadjudicated probation, and we will do 4 years. But you, in a third of that time, I can release you from probation if you do well. There will be terms and conditions of probation, which are normal and customary for this type of offense. Please follow them.
Yes, sir.
If you fail, the probations can be revoked. You can then be found guilty and sentenced up to 2 years in the state jail. So what is the minimum length we can put them on probation? The minimum length on probation is 2.
2, yes, sir.
It is 2. So what's the ruling on early release on 2 years?
I think they have to do it.
I think there's a minimum that has to be served, isn't there?
For deferred, I'm not sure. There is. It's supposed to be some measure.
If somebody receives 2 years deferred or unadjudicated probation for state jail felonies, for example, when can they be released? As early if they, let's say they do well.
I think the first can be early terminated at any time. I don't think there's a.
That's correct.
Limitation on that.
1 day?
I think theoretically.
Okay.
I disagree with that. If
Yeah, I thought there was a
Minimum is
minimum,
2 years.
but it doesn't
It's
happen
gotta be a
often.
third.
We usually,
Two-
yeah,
2
usually,
years.
but at least when it was usually a third.
2 years or a third. With the law.
Yeah. I thought there was, but if it's 1/3 is below 2 years, what's the answer to that?
I think what Mr. Ham is saying is it's a minimum of 2 or it's a third. So you have to do a minimum of 2, no matter what. But now I'm hearing that that's not how.
I thought there was some
I know on misdemeanors. you can get
on
off of a
manifestation, but nonetheless.
Tell you if you want to, because we have a format at work, we can look at it.
Yeah, that'd be interesting. But here, you're,
And the probation officer will also tell you, the actual amount too, because we usually
okay,
tell
I
them.
always thought it was, very close to 2 years on minimum.
3 or something like that. So,
but-
yeah.
That the way that works on this, numerically, it's less than 2 years. Arithmetically, if that rule's going to be applicable under law. But generally, 2 years is a minimum generally, but what we do too is people who do well, the rules of reporting and other conditions are relaxed as rewards for good behavior. So that you're pretty much subject to reporting, but all other conditions except don't commit a crime are generally relaxed. Okay. Then that's what ought to be. You're rewarded for good behavior. Anyway, please see the probation officer and do well, okay? No, it's 4. Dominique Rubin?